In this video, we are going to talk about the first examination report or FER that is received for your patent application, and we are talking in the context of Indian patent application. Now, first examination report is generally a longer document, 4 to 5 pages, or it could be even shorter document as well, depending on the objections that you get. So, irrespective of how wonderful patent application or Einstein level inventions you have filed and exceptional writing skills from the patent attorney, every patent application will receive the first examination report, FER. That is because the examiners at patent office has reviewed your application, and while doing the search and while doing the review, they have come up with some objections. Now, it could be formal objections, it could be technical objections. We'll see it in details here. Now, first thing first, what we have observed is inventor or applicant generally gets in panic. Like when we read the few sentences from FER, first examination report, it would be like the claim 1 to 10 are not novel, they are missing inventive step, or under the prior arts D1, D2, D3, D4, the invention is not at all patent eligible. So because it is missing sufficiency of disclosure, or sometimes even formal objections also part of it. So first thing first, you need to relax a bit as an applicant or as an inventor. Don't panic, because as I mentioned, every patent application will receive first examination report. Now, not panicking and understanding the purpose of FER and what it exactly means and what those documents actually talking about is an important step. Now, you can actually get help of patent attorneys, wherein it is actually the job of patent attorney itself. I mean, they would help you draft a response to it. However, if you want to contribute, the best thing to do would be, have those D1, D2, D3 documents downloaded, study it thoroughly, and maybe create a differentiating table, or let's say you can differentiate what patent office is saying as D1, D2, D3 prior arts, whatever documents they have cited, under which your patent is not novel or obvious or not inventive. You can differentiate those prior arts with your invention and try to come up with some strategy that your patent attorney might be explaining to you over call or over conversation, like a missing feature. In case the feature is missing from the prior art, you can claim that okay, this feature is nowhere there, so hence we should be getting patent. And there are lots of strategies like teaching, suggestion, motivation, TSM. The prior arts, even though combined, actually missing the teaching or suggestion or motivation for a person skilled in the art. So there is no mention over one prior art that it can be combined with other prior arts and come up with the solution of our invention. And there are different strategies and arguments that can be made to overcome the objections. Now, it's not your job, frankly. It's the job of patent attorneys or patent agents. However, if you really want to help them come up with the answers or argue better, you can differentiate the prior arts mentioned in the FER, have them studied well, and differentiate with our invention, how they are different or how we are different than the prior arts. Having that in mind, even if you don't do that, that's absolutely fine. The patent attorneys are capable to do it, but your help would be appreciated. Now, once we have that table, we would argue, or we will write our detailed response line by line, catering to all the objections, maybe formal ones, in case some forms need to be filed, some corrections needs to be made, or if we are making any clerical errors that could be rectified in formal corrections or formal objections. And in the technical objections, we again can argue for the patentability criterias. The response is quite detailed and generally highlighting all the elements of what we already filed or the corrections that we are making. Maybe an amended copy of claims can be also submitted at the time of FER. So long story short, the job of patent attorney is to review the first examination report along with the inventor and prepare and try to overcome all the objections and help patent go to the next step. That would be either a grant or we should be receiving a hearing. So the purpose of this video is helping you understand you don't need to panic receiving an FER. We need to review and differentiate our invention from whatever is found out by the patent office, if it is novelty objection or inventive step objection. I hope this video provides some clarity or some assurance to you and hope you received some value out of it. Thank you so much for your time. Take care. Bye bye.